Hey viewers, welcome. Peter here, Social Foundations of Law and Development. And today's topic is like a seminar on law and development. What is law to do with development? And what is development to do with law? By asking yourself the following question, you should immediately address another problematic question. What is development? If at all, such development has something to do with law or the understanding of law. Okay, let's get started. And I would like to rely and ride on different scholarships when it comes to this discussion. Let's begin by saying that Professor Max Weber is one that has elaborated law and development in his sociology, and that's why he is the outstanding founder of legal sociology. When he writes about law and development in the societies and what really makes capitalism what it is, and coming up with his theory of bureaucracy and his theory of rationalization as well as stratification. Max Weber has done so much to describe and explain to us what is modernity from what is the traditional society. Max Weber is looking at our society in terms of development that is seen as the result of a process. And the process here, which Weber refers to as industrial process, is what makes the entire fabric works. But what brings the economic development the way we see it is what he refers to as Protestant ethic. But however, besides Max Weber, let's again get back to the legal thinkers. General Theory of Law and Development by Young Lee. Young Lee is giving us a very good perspective when he explains the historical development of the entire theory. But remember that law and development are new studies after the Second World War, and the emergence of the Organization of Economic Cooperation and Development, in which the industrialized part of the world and the former colonial powers that actually accumulated some wealth got financially and economically rich and materially rich because of overproduction of commodities that the rest of the world needs. The division of the world between the first world, second world, to the third world was a theory of seeing the first world as the highly industrialized and the highly developed world, and the third world as the underdeveloped, and the second world as that which is developing. But the second world disappeared from the discourse, and we remained only with the first and the third, in which the third was again seen as the highly exploited and the poor countries in the world, or the least developed parts of the world. And that as well brings what would call economic discrimination between populations and their nations. And again, another emergence of neocolonization in which the developed world, badly in need of not now the raw materials, but the natural resources that are so much found within the colonial territories. At the independence, and one of the reasons for calling for independence has been seen as a way of creating the balance between the colonizer and the colonized, and the colonized making claims that needs that freedom to develop itself and get out of poverty, get out of economic instability and some crisis, but also political crisis. But the question still remains to be answered. What is exactly development? Development has generally been understood as economic development under the capitalist thinking versus the communist and versus the socialist. However, still, in 1980s, with the emergence of the NGOs and civil society or non-governmental organizations, the insistence on human development became so loud that economic development was underplayed and seen as not the sufficient or what would call the complete and exhaustive definition of development. Development must be human-centered, must have a holistic approach, and these processes should not be seen to be creating injustice or maybe exploitation of other populations, should not render other populations servants or slaves. In that case, we see development in terms of human development. But how is human development related to law? This is where the question of ideas, notions, perceptions, and conceptions come in. And in this case, we find that legal institutions, judicial institutions play a gigantic role in not only enabling, but enabling human development, which in this case is understood in the millennium terminology as sustainable development. That means development must holistically embrace humanity in its entirety, but also environment. Development that is not careful, is not protecting environment, should not be considered development at all. That is where the question of development related to environment, climate change, and ecosystems should also well be considered as part and parcel of development process. However, from our social foundations, we have talked about social change as a theory. I refer you back to social change theory, in which change should be transformative and change should be seen directionally, should be going towards what is considered positive, a progress or progressive, but should not be seen as stagnated or backward or taking people regressively to the dark age or the age full of conflicts and full of sufferings. So it is progressive, it is transformative in the sense that development, in this case, sustainable development, human development, must focus on what is expected to be the holistic development, and that is where legal institutions or the ideal law kicks in. The ideal law kicks in a proper manner when we look at injustice, what would be considered unfairness. And in that case, law comes in as the administration of justice when it comes to the economics. So development has brought about a lot of injustice, especially international trades, the contracts people sign, the treaties, the agreements, and that one has been seen as well as perhaps undermining developing countries or some countries versus other countries. Other countries are wealthier than other countries. Least developed countries, now even referred to as the global south, are not in possession of the technology they require to continue developing, but also the scientific knowledge they require to continue advancing their policies and plans to develop. Whereas the global north is in possession of science and technology, and they keep on still systematically and systemically undermining and exploiting other populations at their own advantage. And that is where we can apply law to create accountability, to create a system in which humans can seek justice. And that is where law and development is getting its what we'd call coherence. That is where we relate law to gender, we relate law maybe to fishery, and we relate law to our environment, we relate law to our maritime environment. So all this is the question of your focus, and you'll find law and development most largely addressed under the context of public international law and as well as the conflict of laws. But also you'll find law and development addressed at the domestic jurisdictions by individual countries and individual administrations to address policy documents, policy strategies, but also to address their issues and aspirations to obtain sustainable development as per the Millennium Goals. I want you to take home the following. First and foremost, the definition of development. Second, how law is related to development and how development is related to legal institutions and judicial institutions, and how we can apply justice to development processes, and whether development is a process or it is an event that comes and that is it. Let's conclude by saying that now there is more insistence on development that is human-centered, sustainable. We insist on development that insists on good governance, democracy, the rule of law, as well as human rights, constitutionalism. But also we balance it together with equality in our society, so that it is development that integrates all members of the society. We call it holistic development, but also social cohesion and social integration, or social inclusion that sees public participation being applied to the letter by lawmakers and policymakers. With this understanding, I want you to read from Amartya Sen, the professor of economics and Nobel Prize winner, who discusses so much about poverty and culture, economic development that should see that there is that equilibrium between the poor and the rich, and to have a kind of stability in the society that would allow both the poor and the rich to obtain and access social justice, economic justice, and environmental justice, if you wish, political justice. And there is no any iota of discrimination or violations of human rights as we know it. So it is individualistic as well as group-based approach. Having this in mind, the seminar on law and development brings to you a lot of studies, and remember, it is very recent, and these studies are put there under the reading materials, and I invite you to read. Thank you for watching, thank you for being here, and I expect to see you again. I hope you have learned something new, and share it if you find it helpful. Bye-bye.